Good afternoon, everybody, depending on where you are watching this class from. So to do a bit of introduction, myself, my name is Kenny, Kenny Okunola. You can call me Kenny. It's easier that way. I am the Canadian Administrative Law Guide for the NCA Guides. So the NCA Guide is a partnership of 5 tutors, and we each teach different course. So I take the Canadian Administrative Law course. I also tutor the same course at a college in Calgary, Alberta here, called Bow Valley College. I know some of our participants, attendees today are residents in Ontario, so you may probably not know Bow Valley College, but it's a pretty much popular institution in Calgary here. So the program is a partnership, being funded by the government of Alberta in partnership with the Direction for Immigrants in Trades and Professional Careers. And I also currently work in the corporate securities and M&A group of Dentons, in the Calgary offices of Dentons Canada LLP. So that's that about me. What I like to tell my candidate at the beginning of the class is that my introductory classes, and I'm sure some of you would have seen some of my past introductory class videos, I try as much as possible to paint a big picture overview, and I go as deep as possible. I know the traditional introductory classes you see on YouTube or in the internet is usually just something that tries to scratch on the surface. I try to go as deep as I can within the next 2-3 hours. Unfortunately, no matter what I try to do, I can't exhaust Canadian administrative law in 3 hours. I can't even exhaust it in 15 hours, which is why I always encourage people to join the intensive classes. But ultimately, it's up to you. If you finish this class and you feel, confident enough, I always encourage people, my introductory classes are good enough, but then it's up to you to decide what you want to do. All right, so now let's get started on the class itself. I'm going to start with a little bit of introduction. I'm a visual learner, so which makes me a visual tutor too, because I always just assume that if people can't see, they can't learn. So, I mean, again, my own personal bias is, affecting the way I teach too. So, which is why I'm going to share my screen a lot, and I'm doing that right away. So on your screen right now, you see my jottings. I try to call it my class jottings. So I'll start with an introduction of what Canadian administrative law is, and then we will go into the syllabus to see what the expectations of the NCA syllabus is with regards to Canadian administrative law. Then when we are done, the next thing we're going to do is to try and paint a big picture overview of what exactly we want to understand in this course. What is this course itself about? So Barron's Canadian Law Dictionary defines administrative law as those rules of law that concerns the exercise of the powers and privileges of the executive branch of government. It is mostly concerned with the actions and decisions pursuant to the powers given to the executive by the Parliament or and provincial legislatures. Now, admin law is particularly concerned about the rules that exist to control admin tribunals, bodies and commissions, and administrative actions in its broader sense. Now, who does administrative law apply to? It applies to the executive branch. Now, I have in parentheses there that we're going to have to break that down, and we're going to do that shortly. Now, what exactly does this course concern? It concerns the exercise of power. Now, this power that's been exercised, where does it come from? It comes from the lawmakers. Now, this can either be the Parliament or the Provincial Legislative Assembly. So a little bit of background, because I usually just try and skip this because I assume that everybody has been in Canada for 5, 6, 7 years. But then I realized that there will be some of my candidates that will probably be in their first year in the country, or maybe they're even outside the country. Ironically, I've had people that have done the exams from Jamaica. In fact, I had someone that did the last diet from Jamaica, 2 of them from Jamaica, 3 from India, 2 from Nigeria, and they've not even set foot in Canada before. So I try as much as possible to try and break some concepts down, which may be very alien to them, in the sense that, for example, when we say parliament, what do we mean? When we say the Provincial Legislative Assembly, what do we mean? Now, what I'm about to say, you don't necessarily need it for the exams, but if you are new to Canada, it helps you understand this concept, especially if you haven't done constitutional law. So the Parliament of Canada consists of 3 people, let me say 3 entities or 3 individuals, well, not necessarily individuals. So we start from the crown or the monarch. The monarch is sort of symbol, is an idea in Canada. Even though we pledge allegiance to the Queen, we are not necessarily pledging allegiance to the Queen in England. It's more or less now like an idea. So, and that monarch is part of the Parliament. Then also under that is the House of Commons. Now, the House of Commons is the legislative body, and we also have the Senate. Now, the difference between the House of Commons and the Senate is that the Senate isn't elected, and you will do this when you get to foundations and constitutional law. The Senate isn't elected, the Senate is appointed. And I think it's appointed by the Governor General on the advice of the Prime Minister. Now, this is just background information. You may write it down for your own consumption, but you don't need it for the exams. So now the House of Commons are elected lawmakers. So now the House of Commons are members of Parliament that are elected from different ridings across Canada. So now, what are ridings? Ridings are just like constituencies. Like, for example, Ontario, there's a city in Ontario called Toronto, there's Ottawa. So Toronto is going to have different ridings. And the MP that emerges from that riding will represent them in the House of Commons. So now the party with the highest number of MPs in the House of Commons gets to form a government. So the party with the highest number of MPs now gets to form a government, and then the leader of the party now automatically becomes the Prime Minister. So that's just exactly how it works. So whenever we say Parliament, that's what we mean. Now, by now, you probably already also know that in Canada, the executive and the legislative arm are somehow fused together, because you see that the members of Parliament are also cabinet members too. Because you see the Prime Minister is an executive member and he also attends, the Parliament's meetings. Anyways, again, when you get to constitutional law and foundations of Canadian law, some of that will become more obvious. So when we say Parliament, that is what we mean. So technically, the Parliament, in simple terms, are the federal lawmakers. In simple terms, they are the federal lawmakers. And when you do foundations, when you eventually sit for the foundations of Canadian law exam or constitutional law, you will see the process through, the process a law has to follow before it becomes, a bill has to follow before it becomes a law in Canada. It has to go through the first reading, second reading, then there's a committee stage, and then there's a report stage, and then there's a third reading where the members are going to vote on the bill, and then it goes on to the Senate. And after which it has to, receive royal assent before it becomes law. So in simple parlance, Parliament is the federal lawmaker. Now, the provincial lawmakers are called legislative assemblies or the provincial legislative assemblies. So for example, there is a legislative assembly in Ontario. There's a legislative assembly in Alberta. There's a legislative assembly in Prince Edward Island, in Manitoba, British Columbia, Saskatchewan, all the provinces. Now, the difference between the two, it's going to get clearer when we start looking at the sources of procedural fairness obligations and the likes. But what I just wanted to understand right now is the exercise of administrative power is always going to come from either one of these guys, either the Parliament or the provincial lawmakers. Every administrative agency that is exercising administrative powers is not going to come up with that power from just like bring it out of the wind and say, hey, I have the power to exercise admin law powers. No, it has to come from either the Parliament or the Provincial Legislative Assembly. Now, what does this admin law power exactly, what does it do? Now, admin law exactly tries and governs and controls these bodies. Now, let us try and break this down a little bit into layman terms. Let's assume we are not lawyers and we just want to understand exactly what we're talking about. I want to try and paint a picture right now. Is there anyone here? Okay, let me rephrase it because I'm assuming potentially everyone has practiced law. Is there anyone here that has never practiced law before? You practically just got your law degree and then you came back to Canada. Anybody? Okay, so I should probably give this example. All right, so the example I'm about to give right now, in a typical when you practice and let's assume you are a litigator and you have to go to court. So typically what happens is that you, now it depends on what kind of issue you are taking to court. Now I'm just going to generalize it now because I'm not a litigator myself. I'm just going to try and generalize it. Now you go to court and you want to sue someone. You have to file some sort of originating. Now, do you have a question or you're indicating that you have not practiced too?
Yeah, the latter.
Oh, you've not practiced.
Okay,
sounds good. Thanks. So you start by some sort of originating application, right? You file your processes in court. Now, depending on the system of the court, you may be asked to front load the documents. And what exactly do I mean by that? That is, serve the documents on the other parties, discovery. That is, discover, let them know the case to meet. And after which, you get to court, whoever, depending again on the procedures of court, someone is going to go first with their opening statement, and the next person goes with their opening statement. Then you start with the examination of your witnesses. The other party gets to cross-examine your own witnesses that you've examined in chief. And if there are any other issues arising, you cross-examine, you re-examine again after the cross-examination, just to clarify. Of course, there are lots of procedures around this, which is beyond the scope of this course. And in the process of that, the judge is expected to be an impartial arbiter. That is, he's not expected to descend into the arena. The judge is expected to be unbiased, and also the judge is expected to ensure that if somebody says, oh, I'm objecting to somebody, I'm objecting to something, either maybe overrule it or sustain it, depending on their procedures and all that. So what I just described exactly is the procedure the court will follow when the matter comes before them. Now, obviously, these procedures are a bit niche, but some of them may change depending on the type of matter. For example, there are ex parte applications that may not require another party to be in court. There are some appeal applications where the court will not even consider points of, that the court will only consider points of law and no factual issues. So I'm not discussing about all those things. But the basic idea is these are procedures. Now, these procedures ensures that the process of arriving at the decision, at the judgment in that law court is fair. Now, exactly what the court is trying to do right now is that there are administrative bodies that have been established by either the provincial legislative assemblies or the parliament, just like I've explained, which is essentially the federal and provincial lawmakers. Now, these provincial and federal lawmakers made laws that established admin bodies and saddled them with the power and the authority to decide the rights and the interests and the privileges of Canadian citizens, permanent residents, and other people that are presently living in Canada. Now, the courts are saying that's exactly what we do. That's exactly what we do too. Because what does the court do? The court tries to interpret the law, and people go before the court to interpret the law, and the court will tell them this is what we think and this is our decision. That's exactly what admin bodies too are doing. Now, they may be doing it in different subject matter areas, either like the IROC, the Investments Industry Regulatory Organization of Canada, that's an administrative agency, and they deal with securities issues. We have the law societies of the different provinces. They deal with disciplinary matters that affect their members. They're an admin agency too. We've got the IRB, Immigration Refugees Board. They deal with immigration matters. They are an admin agency too. So these guys basically or essentially determines the rights and interests and privileges of people in Canada. And by doing that, they're basically interpreting the law and saying this is what it is, and this is the decision, and that's final. Of course, it's not necessarily final as we come to understand subsequently. But the point is they are exercising power and authority over individuals in Canada, exactly the same way the court is doing it. And the court is saying, well, if you are going to do that, then you have to do it within the bounds of the rule of law. You must not go beyond the scope of the rule of law. You must, if you are, doing this, it has to be procedurally fair. That is, the procedure that you will follow to arrive at your decisions must be fair. And how do we know a procedure that is fair? That is the whole concept of procedural fairness obligation that we're going to get into shortly. Now, that's just part A of what the courts are hoping to achieve by monitoring these admin agencies. Part B of that is that the courts also expect that the actual decision itself must be correct, or let me say must be the right decision. So there are two things. And you know, and I'm going to be talking more. So I'm going to be talking a lot from my answer framework, and you guys will see a lot of charts coming up, you know, on your screen in the course of our discussion today. So you can see that generally administrative law overview, it's basically, we can divide it into procedural fairness obligation and substantive review. So essentially what these two are saying is, if an admin agency has been saddled with the power to determine the rights, interests, and privileges of individuals, the courts are going to serve as a watchdog and ensure that the process of arriving at those decisions is fair. And that is what we are examining in procedural fairness. Now, I'm sure for some of you that have started studying, you know this is a lot. We're going to have to talk about a lot under procedural fairness. As a matter of fact, procedural fairness takes 70% of our time if you eventually come to the intensive classes. And the other part of what the courts are going to try and ensure is to make sure that the actual decision is the right decision. So there are two different things. So if, for example, Denise comes before me as the administrative decision maker and says, "Hi, Kenny, I want to apply to you to pass the NCA exams." And I'm like, "Okay, present your documents to me." And then I review a document and I say, "No, you are never going to pass." No, let me not use a negative example. And I say, "You have to do certain additional things before we can admit that you are now a lawyer in Canada." And those additional things are to write several exams. And then I tell you to write 10 exams. And you are not happy with that decision because you're like, "Why should you give me 10 exams?" But if you now approach your lawyer to help you review the decision of the administrative decision maker, which is me, the first thing your lawyer is going to ask you, because your lawyer knows that when it comes to reviewing administrative decisions, it's not really just about the decision itself. Your lawyer is going to ask you first that, "Can you tell me about the process that was followed before Kenny arrived at his decision?" And in asking that, your lawyer is going to ask you, "Did Kenny give you notice that the hearing is about to start? Did Kenny allow you oral hearing?" Just like in the courts. Remember when I was making that example of starting the process in courts? Did Kenny give you, opportunity to know the case to meet? Discovery. Did Kenny allow you to have a right to counsel? Did Kenny allow you to cross-examine different information and people and witnesses? Was there oral hearing? Was there any sort of bias? Did Kenny descend into the arena and he was biased? And of course, we're still going to talk about all these things in detail subsequently. So those are the procedures. Now, the lawyer is going to ask you those questions because the lawyer wants to know whether he can challenge that decision only on the procedural defects, on the procedural grounds. Now, if that isn't successful, the lawyer will now ask you, "Okay, let us look at the decision itself. Why did Kenny decide that he should get 10 exams instead of 5? Now, in looking at the decision itself, you can't just say, "Well, it is wrong," or "it is right." You need to review it by some standards. And those standards are what we refer to as the standard of review. Now, let's pump the brakes right there. I know I'm probably going too fast for some of you that have probably not studied yet. Now, before we go further, let's go into the syllabus and see what the NCA is expecting, for us as candidates to know before we can successfully pass these exams. So the syllabus was revised for June 2022 exams, which means it's going to take effect for your own exams also. And you can see the introductory paragraph here. The NCA says, "Admin law is the body of law regulating the ways in which government operates. It's about the rules and limits that apply to not only the operations of the Crown, cabinet ministers, government departments, and municipal corporations, but also the various administrative tribunals and agencies governments use for the carrying out of governmental functions of all kinds. Now, I know this sounds like a very complicated statement, but basically what they're saying there is there are agencies that have been established by law. Now, even though they were established by the law made by the legislative arm of government, they are technically operating as an executive arm of government. Does that make sense? So they are operating within arm's length of the executive, which is why my jottings right here says, whom does this apply to? It applies to the executive branch, because admin agencies are technically categorized as part of the executive, but their existence was brought to life by the legislature. Now, the judiciary now serves as watchdogs to ensure they are doing the right thing. That's exactly what we are doing in administrative law. The context, the whole crux of the discussion on administrative law is ensuring these admin agencies are doing the right thing, in layman's terms. So now, to ensure they are doing the right thing, we need to be reviewing the processes they are following to arrive at their decisions, and we need to review the actual decisions itself. That's exactly what we're doing. Now, moving on, the NCA is also telling us that it is concerned with the procedures by which all these various instruments of government, that is, all these admin agencies, it is concerned with how they operate, the substantive scope of their mandates, and the remedial structures that exist to ensure that decision makers of various kinds act in accordance with the rule of law. Again, a lot of English language there. What it's concerned with is these ADMs. Their mandate is in the enabling law, right? The law that established them. Remember, no ADM is existing just because they thought or they wished them into existence. They are existing because the lawmakers already made a law to establish them. Now, when they establish them, the scope of their mandate is always there to know what they can do and what they can't do. The remedial structures, in case an individual, or we call them in admin law context, anyone that is aggrieved by the decision of an administrative decision maker, we call them applicants. So the remedial structures that exist for an applicant will also usually be in the enabling law, and also to determine whether they are acting in accordance with the rule of law. That is, are they doing the right thing? Now, some regard admin law as a subset of constitutional law. You know, we don't need to worry about that, but it's not really a subset. It deals with different things. Now, these are the primary questions considered in this course. The circumstances under which governmental decision makers are subject to an obligation of procedural fairness to those affected by their decisions, and where applicable, the content of that obligation. That is, what kind of procedures should have been followed? Were they followed? What is the remedial nature of, the approach? Now, the extent to which substantive decisions of ADMs are subject to merit scrutiny by the court. Again, this talks about the actual decision itself. Remember, I told you administrative law can be divided into two, basically: procedural fairness, substantive review, and of course, what are the remedies? So the same thing is what the NCA is saying. What did they follow the right procedures? That's the very first issue. The second issue is, did they follow the right procedure? The second issue is the decision itself correct? And the third thing is, what remedies are available? What remedies are available? Did they follow the right procedures? Is the actual decision itself correct? And what remedies are available? That's exactly what we are considering in admin law, or that's what the NCA expects us to consider. Now, the syllabus is also saying some of you will bring to this subject some knowledge of admin law acquired during your legal studies in other jurisdictions. Sometimes that knowledge will be useful, even if the applicable case law is different. However, be very cautious in relying on knowledge gained elsewhere. There are some very distinctive aspects of Canadian public law that do not find analogs or exact parallels in other jurisdictions, including those sharing a common law or Commonwealth heritage. In answering the exam in this course, you act at your peril if you automatically start applying the principles and the case law from the jurisdiction of your initial legal training. Now, that's what the NCA is expecting. Of course, there are case books. I'm pretty sure you guys must have gone through this. If you haven't, the syllabus should be your first material before you start studying any notes. So you should go through the syllabus first. The good thing is for every chapter, we discuss, well, not we can't finish everything in this class, obviously, but every chapter that is being discussed in the intensive class, we always start with the syllabus. And the idea behind that is that we want to see exactly, because this is the marking scheme. People say, can we have the marking scheme? This is the marking scheme. So we put everything together line by line and ensure that we have answered every question asked in the syllabus. And you will see, these are the supplementary texts. The main text was updated this year, the 2022 edition. And I think I actually have it here. I think I have the 2022 edition here. And yeah, so chapter 1 talks about setting the stage. Chapter 2 talks about the sources of procedural fairness obligations. Chapter 3 talks about the triggers, the ninth three-pronged trigger, and the concept of legitimate expectation. Chapter 4 talks about legislative decisions and emergencies. Chapter 5 talks about the Charter and the Bill of Rights. Chapter 6 talks about constitutional duty to consult and accommodate Indigenous people. Chapter 7 talks about the right to be heard. That's the content of procedural fairness itself. Still on content, unbiased and independent decision makers. Still on content, issues arising from institutional decision-making issues. Before we now go to the second half, which is the substantive review aspect. Remember, like I said, admin law, procedural fairness, and substantive review. Those are the two main aspects. And under the substantive review, we're going to do a bit of a historical analysis to the backdrop to the standard of review analysis before, and in that, under that, we're going to talk about how the standard of review evolved from the Bibo era to the Dosmere era to Vavilov. And also we're going to look at the actual test that we're expected to follow right now, which is the current test on standard of review. And of course, we'll look at the venue. If you want to challenge an administrative decision, where do you go to? Do you go to the Superior Court? Do you go to the Section 96 Court? Do you go to the Provincial Superior Court? Do you go to the Federal Court? Or do you go to the Supreme Court of Canada? I'm not sure about that. So we're going to look at the different options available in that regard also. And finally, we will look at remedies. If you have gone to court, what remedies should you ask from the court? What remedial options are available to you? Okay, so let's try and do a bit of a big picture overview, and let's see how far we can go. So that's essentially the introduction to Canadian administrative law so far, the definition rather, sorry. Now, let us try and take a look at procedural fairness. Remember I said admin law can be divided majorly into two: procedural fairness, substantive review, and of course, the third unpronounced part is what remedies are available. Now, let's take a look at procedural fairness. What do we mean by procedural fairness? Like I mentioned, in procedural fairness, we are trying to ensure that the decision maker follows the proper procedures in arriving at their decision. Now, how do we know that the decision maker has followed or employed the right procedures? It's simple. The very first thing you need to know, or you need to ask yourself, is what are the procedures that ought to have been followed, right? Because if you want to know if someone has followed the proper procedures, you need to know what the proper procedures are before you can say they didn't follow them or they did. Now, in your notes, for anyone that has notes, if you don't have any notes and this is like your first exposure to admin law, then maybe you need to get some notes before you understand what I'm saying. But in your notes, you will see some content of procedural fairness obligations. You will see it can either be divided into right to be heard and right to an unbiased decision maker, which is exactly the way the syllabus has divided it, or it will be divided into pre-hearing issues, hearing issues, or post-hearing issues. It doesn't matter how they divide it. They are talking about the same thing, okay? How they divide it it's not the issue now. The most important thing is the content. So when we say right to be heard, right to be heard may include things like notice, right to be heard may include things like notice, discovery, delay, oral hearing, open hearing, right to counsel, disclosure and official notice, which may also include things like privilege, commercially sensitive information, staff studies, cross-examination. These are all procedural fairness obligations that can be categorized under the right to be heard. Also, right to an unbiased decision maker can include things like reasons, bias, prejudgment, institutional issues like deciding without hearing, overlap of function, agency counsel, agency guidelines, and things like that. Now, for the other type of division, you will see that the contents are the same. They just divided them into 3. So, for example, pre-hearing issues. Some authors decided to say, okay, let's go by the stage of the hearing that they are applicable to. So, for example, a pre-hearing issue will be noticed in most situations. Discovery in most situations will also be a pre-hearing issue. Delay can occur anytime, but in most situations too, it will be a pre-hearing issue. Now, hearing issues, things that happen during the hearing itself. It can include things like, oh, were you granted oral hearing? Was the hearing done in the open? Were you granted the right to have a lawyer or any sort of representation? Are there disclosure issues like, commercially sensitive information and staff studies? Were you allowed to either cross-examine a document or an individual that's a witness? So you see that these things are things that potentially will happen during the hearing, which is why some authors have categorized them as hearing issues. And then post-hearing issues are things that happens after the hearing, like after the hearing and the decision has been made, did they give you reasons for their decision? That's a procedural issue. If they made a decision and they didn't give you reasons, it's a procedural issue. Was there bias? Again, bias can arise anytime, but we just like to just categorize it as a post-hearing issue. Were there any sort of institutional issues and any other post-hearing issues that we should be worried about? So it doesn't matter how it's divided in your notes. What matters is that the content is all there. Okay, so let's go back up. Now, when you are claiming that you have been wronged by an admin decision maker, that they've made a decision that doesn't make sense, if you go head over to your lawyer's office saying, hey, Kenny, I know you are my lawyer, you are a great admin law expert, and I want to just tell you that my, what's it called now? I want to tell you that the decision maker made a decision that I don't like, right? The very first question I will ask you as your lawyer is, okay, if you are saying that they made a decision you don't like, I will ask you questions to kind of, elicit information on the procedures they followed, and then also ask you what the decision itself is. So on the procedure they followed, I will ask you things like, were you granted notice? Was there discovery? Were you heard in person orally, or was it written hearings? Was there any sort of overlap of functions? Was there bias? Now, let's assume that Denise now tells me that, oh, they didn't give me reasons for their decision. They were so biased. They even prejudged me. They didn't allow me the right to disclosure. I didn't even know the hearing had started in the first place. They didn't give me notice. Now, those are 6 procedural fairness issues that Denise has mentioned that I'm going to latch onto, right? Now, the next question I'm going to have to now answer as a lawyer is, does Denise have the right to those procedural fairness obligations? Because if Denise is saying, they didn't give me oral hearing, they didn't give me right to counsel, I wasn't allowed cross-examination, okay, fine, they didn't give it to you. But the next question is, are you entitled to that right? So in knowing whether you're entitled to that right, we will now need to consider the sources of procedural fairness obligations. See the ones that are applicable to Denise and the decision maker, and see whether she is entitled to the right she's claiming she was denied. Does that make sense? Pat, you have a question? Pat? Did you mistakenly raise up your hands? I'm assuming that's a yes, except you're on mute and we can't hear you. So I'll proceed with the assumption that that's a mistake. All right. So now you are claiming the right to certain procedural fairness obligations, right? So the next thing that makes sense is to now find out whether you're entitled to those procedural fairness obligations. Now, the sources, what are the sources of procedural fairness obligations available? We have the enabling statute of the administrative decision maker. Remember we said the decision maker is not wished into existence. They must have been established by a law. So that law is what we refer to as the enabling statute or enabling legislation. That is the law, the statute that enabled them, that brought them into existence. So these enabling statutes, most of the times, will contain certain procedural fairness obligations, which is why it is the first one you have to consider. You have to consider whether it contains those procedural fairness obligations. And of course, for every source, there's a trigger. That is, you have to be sure that the source is applicable to the case you are reviewing. Now, for the statute, the trigger is always in the statute. What exactly does that mean? We're going to talk about it subsequently. Now, when we say threshold, so and by the way, this is called the STTC formula. Threshold basically talks about whether the trigger, or let me say the source of procedural fairness obligation and its triggers, in applying it to the question you have been given in the exam, you need to determine whether the threshold of application has been met based on the fact of the scenario. So that process is what we call the threshold analysis. I will do a threshold analysis for you with one of them as an example so you understand what I mean. And then when you're done, the next thing is, of course, the content. So what do I mean by content? Content means we interchange these words. We use the word content. We can also use another word that is similar, which we call procedural fairness rights. We also refer to it as procedural fairness obligations. So whenever you hear content rights, procedural fairness obligations, this is what we mean. These guys right here. That is notice, oral hearing, discovery, disclosure, the actual procedural fairness obligations that ought to have been granted. Those are the ones that we refer to as content rights. Now, according to the syllabus, before you start your discussion on those content rights, you need to start with the Baker factors. I didn't make that up. It's in the syllabus. Let's read it. Let's read the syllabus so you can see that. Can I get a volunteer to read? Can I get a volunteer to read? Anybody? Denise, do you want to give it a try?
Sure. Confused. Yeah.
Okay, so let's just read. You know what? We're going to come back to this subsequently, but for now, let's just read this part. Where is it? Sorry, one sec.
Do you mean from the basic issue is this, and then certainly
yeah,
Baker considerations?
Yeah, let's read from here.
Okay. The basic issue is this: the precise content of procedural rules coming from the common law, charter, or Bill of Rights varies from case to case according to the circumstances. Certainly, with respect to the right to be heard, you must start with the Baker considerations. Baker gives you a non-exclusive list of considerations that tell you at least something about content. Specifically, the Baker test suggests whether the content will be robust or not. It actually tells you a little bit more if your trigger is legitimate expectations. With legitimate expectations, the content of the procedural obligation is generally what was promised in the procedural promise that gave rise to the legitimate expectation in the first place.
Yeah,
promise was
you can put a pin in it there. So
okay.
what I just wanted to point out at this stage, because we're still going to come back to this chapter subsequently, what I just wanted to point out at this stage is that with respect to the right to be heard, which is where you start your contents. Remember when I was telling you that it could be, contents could be divided into right to be heard or right to a non-biased decision maker or pre-hearing, hearing, and post-hearing issues. Unfortunately, the syllabus adopted this, division. So, and the syllabus is telling us that with respect to the right to be heard, which is the very first step in your content discussion, you cannot go into the right to be heard directly. You have to start with the Baker considerations. That's the point I wanted to bring out there, which is why under this STTC formula, after you've talked about the sources, the triggers, and you've applied the fact of the case to know whether to do the threshold analysis, and you want to discuss the contents, you can't just start discussing the contents. You have to start with the Baker factors. That's the point I wanted to point out there. Now we're going to come back to that and read the entire chapter if needed. But for now, let's now go to the sources. So we talk about the enabling statutes. General procedural statutes. Now, general procedural statutes are provincial laws. They are provincial laws that applies only to specific provinces that have made them. Now, so far we have about 4 of them. Well, 5, but 4 for 4 provinces. We have the statutory powers and procedures. Now, this isn't protection. Please ignore this typographical error. Statutory Powers and Procedures Act, the SPPA, which applies in Ontario. We have the one in Alberta, which is the Administrative Procedures and Jurisdiction Act, and the one in Quebec, which is the Act representing administrative justice, and the Admin Tribunals Act in BC, and of course, we have some other procedural codes in Ontario. So now the implication of these general procedural level laws is that before you know if it's going to be applicable, you need to determine who established your administrative decision maker. Remember, what did I tell you guys at the beginning of the class? I said administrative decision makers are going to be established by law, and they are either going to be established by who and who, the Parliament or the Legislative Assembly. If an admin decision maker is established by the Parliament, it means that admin decision maker is what? Is a federal admin decision maker. If they are established by the Provincial Legislative Assembly, that admin decision maker is a what? Is a provincial admin decision maker. Now, to start with, if your decision maker is a federal decision maker, this will not even apply to them at all because they are provincial laws. Now, even if your decision maker is a provincial decision maker, it's not automatic. You have to be sure that your decision maker is either Ontario, Alberta, Quebec, or BC. So if it's any of those 4, then this will become applicable. Now, it doesn't even stop there. Again, those are the things we can't treat in detail in this class. You will need to even now examine those provincial procedural laws, because some of them will even tell you the ones, their decision makers that they don't apply to. Does that make sense? Does it make sense? Okay, let's do an example. Let's take a look at the SPPA in Ontario. That's the Statutory Powers and Procedures Act in Ontario. Let's take a look at it. And let me show you guys what I mean. I like looking at it on Canly. The way you guys should have access to LexisNexis once you registered for your exams. So that's a very good resource to always check out some of these things. So when you take a look at this is the Statutory Powers and Procedures Act in Ontario. Now, This in section 3, it tells you that it basically applies to any tribunal in Ontario. That's basically what it's saying. Now, in section 3.2, it's now saying, well, despite the fact that it applies to different ADMs in Ontario, there are some that it doesn't apply to. And it's saying it doesn't apply to these guys right here. And the reason is because the rules of civil procedures already apply to them. They are mostly courts, Court of Appeal, Superior Court of Justice, small claims courts. They already have their own civil procedure rules, which is generally like any procedural rules of courts. And these rules are similar to this procedure. Remember, the whole point of this admin law saga thing is just to ensure that they are doing the right thing. Now, the courts are already doing the right thing. So there's no point trying to review what they're doing already since they're already doing the right thing because they have a civil procedure code they are using, right? It also doesn't apply to any, decision maker to which the rules of civil procedure applies. It doesn't apply to an arbitrator to which the Arbitration Act of 1991 or Labor Relations Act of 1995 applies. It doesn't apply at the coroner's inquest, commission under the Public Inquiries Act, blah, 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 blah. So the point of that is just to show you guys that when it comes to general procedural statutes, the very first thing to find out is my ADM provincial or federal? How do you know if your ADM is provincial or federal? Go to the enabling law. The enabling law will tell you whether they are provincial or federal. Now, one of the assignments that we, often do in class, let me show you, let me open one of the assignments we've done in the classes before. Assignment 1, I think it's assignment 1. So one of the assignments we did in class we are going to do in class rather, we give you something on the SIRA, and attached to this SIRA assignment is a SIRA legislation, the enabling law rather. Sorry, I want to try and open that, but my computer is misbehaving. Yeah, so now, as you can see from this attached legislation to the assignment, this already tells you that this is an act of the Provincial Parliament of Prince Edward Island. So it's easier for you to know that this is a provincial decision maker. But sometimes it won't tell you anything. It won't tell you, it won't even give you an enabling statute. That's crazy, right? Let's look at the sample exam question on the NCA's website. Now, on the NCA's website, they didn't give us any enabling law. So one thing I should probably mention at this stage is that there are two ways your exams, your exam format is going to look like. Now, of course, there are about 4 different exam question types, but format in the sense that you are either going to have a question like this, and they will annex an enabling law to it, or you have a question like this and they won't annex any enabling law, but they will copy and paste sections of the law within the question itself. So when you get questions like this, there is no way you're going to know, because you're not going to get an enabling law that gives you the heading of the law that says this is an act of the Provincial Parliament of Canada or the act of the Parliament of Canada itself. So if you don't get a law like this, then if you get something like this, then the next thing you need to think about is you need to ask yourself, what is the subject matter of the issue? In this annexes question, the subject matter here was human rights. And most often than not, the Human Rights Commission is always going to be a federal decision maker. Another thing that can help you out in determining that is to essentially, if you haven't taken constitutional law before, just go to either Canley or LexisNexis and look for section 91 and 92 of the Constitution. So section 91 and 92 basically talks about the division of power between the provincial and federal governments. So when you take a look at the content of section 91 and 92, you will see now I may be mixing it together. Please do your research. We're not in constitutional law class. Section 91, either one of them, I think section 91 talks about the federal powers. Section 92 talks about the provincial powers. You can just print it out in a page. Just make a document yourself, print it out in a page. So if you ever get an exam question now, that's something you should probably worry about, 1 week to the exam. You don't need to worry about that right now. So if you ever get an exam question like this and you're like, oh, How do I know who established my decision maker? Because they didn't even tell us, apart from the fact that I know based on experience that human rights is always immigration too. Even though immigration is somehow shared, but it's most often than not going to be federal, because the IRB isn't a provincial body. The immigration body, the IRB, which is the decision-making body for immigration-related issues, it's not a provincial body. But there are some parts of immigration that the provinces also deal with. So that way it's easier for you to know that, oh, if this is a provincial, then it has to be a provincial decision maker. If this is federal, then it has to be a federal decision maker. Now you're going to need that information really, because you will need it here to even know whether to waste your time here or not. You will also need it when you get here, because for the Bill of Rights only applies to federal decision makers. It doesn't apply to provincial decision makers. So let's take a step backwards. So now, General Procedural Statutes only applies to the provinces that have made them, and we already know those provinces are Ontario, Alberta, Quebec, and BC. Then when it comes to the common law, the aim of the common law is to sort of fill in the gap, or fill a lacuna if the statute is defective. And most often than not, the statute is not going to cover all the procedural fairness rights you need. Remember, the example I gave you guys, Denise came to me, she mentioned that there were 6 procedural fairness issues in a admin law hearing, admin decision hearing, and she feels like she was, she wasn't heard properly. There was no right hearing, right to counsel, blah, blah, blah. Now we've looked at the enabling statute, and the enabling statute only provides for one procedural fairness right. That's where the common law comes into play. The common law talks about the general existence of a duty of fairness. That is, it doesn't matter, because the common law isn't codified laws. It's not like it exists in a pamphlet or in a hard copy, binder or somewhere. It's just, the product of judge-made laws, which was for people that studied in the UK or in any common law country. You remember the Judicature Act that fused both principles of equity and common law together. That's what we're talking about right now. So these things developed based on that premise. And common law basically says, if you can pass some certain tests, then any procedural fairness obligation that the applicant is entitled to that's not in the enabling statute, and the statute does not expressly contradict it. Please pay attention to that. The reason why I said that is that the common law can't change the statute. It can only fill in the gap. So if the statute expressly mentions that you will not have a right to something, even if the common law is triggered, you won't have a right to it. But if the statute is just silent and then the common law is triggered, then you have a right to it. Does that make sense? So, because if the statute expressly forbids a procedural right, then you need to start looking at the charter, not the common law. And we're going to get to that place shortly. So how is the common law triggered? There are 2 triggers for the common law. The first one is called the Knight 3-pronged test, and the second one is called the concept of legitimate expectation. So the Knight 3-pronged test are 3 factors. There are 3 factors around the Knight 3-pronged test, which talks about, where is it? I should have it somewhere here. Yeah, these are the Knight factors. The first one talks about the nature of the decision. And, when you're looking at the nature of the decision, you want to determine whether it's an admin decision or a legislative decision. You also want to know whether it's a final or a preliminary decision. Because the reason behind that is that legislative decisions are not, they don't attract procedural fairness. There's no duty to be procedurally fair if your decision is termed or is found to be a legislative decision. But admin decisions, you're expected to be procedurally fair. Also, final and preliminary decisions. For preliminary decisions, you are trying to determine whether the decision is still ongoing and not yet final, because if it is ongoing, then there's no need to cry foul and say it wasn't procedurally fair. But if it's a final decision, then it makes sense for them to have been procedurally fair and all that. Now, of course, there's a whole lot of discussion on how to identify what a legislative decision is and what an administrative decision is. I'll just quickly go through that because of time. So the differences between legislative and administrative decision, in a legislative power flow, you are thinking of a sort of delegated lawmaking power. Because remember, I said admin decision makers are established by law. from the provincial lawmakers. Now, when they establish that law, they usually give them two types of powers. There's an admin power, that is the power to determine the rights, interests, and privileges of individuals. And then there's also a legislative power, which is what the power to make laws. That is laws that affect their own operations. So those are the two major types of powers that they've got. And in doing that, that's a simple way of explaining that. However, there are some times when the decision maker will make a decision and they will say, oh, we made an admin decision, not a legislative decision. Or they will say, oh, we made a legislative decision, not an admin decision. But the court won't just take their word for it. The court will examine what the decision itself entails. Because when it comes to admin decision, it's usually about applying the law. And the application is always specific. For example, Denise was before an admin tribunal before she came up to me. So when the decision maker was applying that law to her, it was to her. It wasn't just to some unknown individual. It has to be specific when it comes to admin law exercise of power. But when it comes to the legislative power, it's not about applying a law. It's usually about making a law. And when you're making a law, the law must be sufficiently general in application and not particular to or focused on a narrow subset of persons. I didn't make that up. It's in the syllabus. It's under the legislative decisions and emergency chapter of the syllabus. Yeah, it says here that a legislative decision means more than this. Boiled down to its essence, it can be a decision that is sufficiently general and not particular to or focused on a reasonably narrow subset of persons. What does that mean? Let me quickly break that down, even though we don't have time. So basically what that means is, even when a decision maker decides to exercise their legislative power, now they are not technically determining anybody's rights, interests, and privileges when they're exercising this power. And that's why it doesn't attract the duty to be procedurally fair. Okay, let me give you guys a bit of a background. When you study for foundations of Canadian law, you will go through this topic called legislative or parliamentary supremacy and parliamentary sovereignty. What that means is that only the parliament or the legislative assemblies, that is, only the lawmakers, have the power to make laws in Canada. That's what it means. Of course, there are some attendance issues, there's an ongoing discussion about what about international treaties, that the lawmakers aren't always subject to the meetings when they're making those international treaties. It's always the prime minister and the cabinet members, which is why if they make any international law, it doesn't take the force of law until it is domesticated into the country. Why? Because of the concept of parliamentary supremacy or sovereignty. Also, another thing about parliamentary supremacy is also that in the process of making law, they don't owe anybody any explanation. The lawmakers don't owe anyone any explanation, even to the indigenous groups. When you do foundation of Canadian law, you study the concept of duty to consult. Now, the duty to consult does not extend to lawmaking process. Now, when the law is done, they can consult them, but the parliaments have that power that when they're making laws, they are the only ones that can make laws, and also they don't have to be procedurally fair in the process of making those laws. Now, because the legislative power being exercised by these decision makers is not from them, it's not their own power. It was delegated upon them by the parliament or the legislative assemblies. Technically, it is still the parliament that is still exercising that power. So that concept of parliamentary supremacy still applies, which is why legislative lawmaking power for admin decision makers does not attract procedural fairness. However, what the court is now saying here is that if you are making that law, make sure that law is sufficiently general in application. Because if the law is not general and is focused on someone, that is already starting to look like what? An admin law power. And what is an example of a law that is not general? Remember when they were making bylaws that people should start wearing masks in superstores and Loblaws, outside. Just imagine that they made a law and they said every Black female that is on braids should start wearing masks. That's not general in application anymore. Now it's a law. It's a law, all right. It's quite all right, a law. But it's no longer general in application. It is now what? It is now particular to or focused on a reasonably narrow subset of persons, which is Black females on braids. Or if they say every gay or queer people must be on masks. Or remember when anti-maskers were saying we don't want masks. What if they now made a law and said every white person is not required to be on mask? That is no longer a law. That is a decision. Because now it's affecting the rights, interests, and privileges of a specific category of persons. So that's just the the interaction between legislative law and legislative and admin power law, power flow. And it's something I think you should probably pay attention to, especially when you are discussing this nature of the decision under the Knight factors. Remember, we got to that because we're looking at the Knight factor triggers. And again, we're going to take a look at that in detail in class because there's just a lot of principles to just go through, unfortunately. Now, the second factor is the relationship existing between the admin body and the individual. And the third factor is the effect of the decision on the individual's rights, interests, and privileges. Now, these three factors, we call their, there's a word I use for them. I can't remember them anymore. But the point of these three factors is that all three factors must point towards the existence of that duty of fairness. So how do you know that they are pointing towards the existence of the duty of fairness? For the nature of the decision must be administrative in nature and not legislative. It must also be what? Final and not preliminary. So if you can say the nature of the decision is admin and final, then the first factor checks out. The second factor, the relationship must be pursuant to the enabling law of the decision maker. It mustn't be pursuant to a contract of employment. Now, even if it is pursuant to a contract of employment, it has to fulfill what we call the Dosmere Exceptions. So there are 3 Dosmere Exceptions that the court came up with. If it aligns with those exceptions, then it checks out. Then the third one, of course, the decision must be important to the individual because it's now that's a very subjective factor, which is usually not difficult to pass the threshold. So all 3 factors must point towards the existence of the duty to be fair. Once all 3 factors point towards the existence of the duty to be fair, we can now say the common law has been triggered. And once the common law is triggered, the various procedural fairness rights that were not provided for and not expressly forbidden by the statute will not be made applicable. Now, the Knight factors isn't just the only trigger. We also have another trigger called legitimate expectation. Now, when it comes to triggering the common law, you can use both or you can use either of the two. So what is legitimate expectation? Legitimate expectation speaks to sorry, one sec. I'm just trying to figure out this thing out. Does anyone have any questions so far?
So far, so good, I guess.
Okay, so for legitimate expectation basically deals with the fact that someone has expected something, even though it's not provided for by law, but because they've expected it and they are entitled to expect it, then it should be done. Now, what exactly does that mean? Now, legitimate expectation can come in 2 different forms. It can either be expressly or implied from practice. So the whole idea of legitimate expectation is that a promise was made. And because that promise was made, and the person is qualified to make that promise on behalf of the decision maker, that is, it doesn't go against the person's statutory mandate, then it is expected that they have to abide by that promise. And in doing that, exactly what they need to do is just to ensure that, oh, how is this promise being made? Now, it's either going to be expressly or implied from practice. Now, legitimate expectation is express if the promise is either written or oral, that is said in person. And if that is done, it basically means that, oh, say, for example, I come on this screen right now and I say, anyone that joins my classes, I can guarantee you that you're going to pass the NCA exams. Now, it can create a sort of legitimate expectation because I've made that promise. Well, technically, I don't even need to make the promise. It's something that happens by default anyways. But I just made a promise expressly, right? Or maybe I wrote it down, right? Now, when we say it is implied by practice, it's not express. Nothing is written down. Nothing is oral. Or nothing is said, rather. Nothing is written down. But you can see a series of past practices. And based on those practices, you don't see any reason why the practice shouldn't continue because it's your turn. A very good example is, now, say, for example, when you want to write your NCA exams, everyone is giving, I know the NCA has changed the hours from 4 to 3.5. Now I think it's been changed to 3 hours from September, right? Now let's assume the NCA didn't notify anyone that they were changing the hours to 3 or to 3.5, but then they've changed it to 4 hours because when I wrote my exams, I didn't write my exams online. I wrote my exams in person at the Law Society, when it was still in person and all that. And the exams were written for 3 hours, right? But when the COVID pandemic started and they started writing exams online, the NCA added 1 hour because they felt like it was difficult to write the exams online. Now, the NCA has been conducting the exams online for 4 hours every time. Let's assume they haven't sent any notification to anyone that we're reducing the exam time to 3 hours or 3.5 hours. You then log on your exam day. You've already practiced, with the expectation that, well, they've been giving everyone 4 hours. I don't see any reason why they are going to change now, right? And then you log on to your exams and then you see your countdown 2 hours, 59 minutes left. And you're like, what? I thought it should be 4 hours. Why did I get 3 hours? Now, you can claim legitimate expectation based on past practices. That is, that since the pandemic started, the NCA has been offering their exams online for 4 hours and not 3 hours, even though no one actually made a promise. So that's the second aspect of legitimate expectation. The only caveat to that is that you have to know about that practice because you can't have an expectation that is legitimate on implied past practices when you don't even know about the practice. Say you just came to Canada, you don't even know the NCA was doing the exams for 4 hours. You thought it was 3. And then you're like, oh, why did I get 4 hours? And you don't know about it. Someone asked me a very intelligent question in a previous class that, well, how are they going to know that I don't know? Is that not a very interesting question? No one thought about that. Okay. How are they going to know that I don't know? It's very simple. Just look at your exam question. Whatever your exam question says, if the exam question says that you don't know or the applicant doesn't know about that practice, then the applicant doesn't know. If the exam question says that they know, then they know. If the exam question is quiet or silent, rather, if the exam question is silent on that subject, then you are free to make assumptions. But you have to state your assumption that I am assuming the applicant is not aware, or I am assuming the applicant is aware of this past practice. And then there goes your answer. Anyways, I also try to liken legitimate expectation to promissory estoppel, which most people are used to in a law of contracts. The only difference between promissory estoppel and legitimate expectation is that you don't need to establish proof of reliance. In promissory estoppel, you have to show that your position has changed. right? But in legitimate expectation, you don't need to show anything. Just show that at least the promise was made, or there's a series of past practices, and all that. And there's also a caveat when it comes to legitimate expectation, and that's what we say: you cannot use legitimate expectation to generate a substantive outcome. So what do we mean by that? A substantive outcome is an outcome that doesn't lend itself to the procedures. So for example, if the NCA promises you, okay, let me give you an example. If the Prime Minister goes on TV and says, remember when everyone lost their job, during when the pandemic started and all that, and the CRB thing started, and the Prime Minister went on TV saying, we are going to give every Canadian the Canadian Emergency something benefits. I don't know what the R stands for anymore. What if the Prime Minister went on TV and says, everyone that has lost their job, we're going to give them their jobs back? Do you think that's a procedural promise or substantive promise? Anybody?
Repeat it again, please. Sorry.
Okay, let me give you another example.
Okay.
When the pandemic started and the NCA promised that they were going to add 1 hour to the exams, and the exam time isn't going to be 3 hours anymore, but 4 hours. Is that a procedural promise or substantive promise? Remember, procedural promises lends itself to the procedures. Substantive promises is actually the outcome.
Can I say substantive promise?
Why? Why do you think it's substantive?
How to put it? Because
do you think the NCA adding 1 hour to your exam time is a definitive outcome? The first question you ask yourself is that when you're writing the NCA exams, what is the definitive outcome for you for writing the exams? Why are you writing the NCA exams?
To pass it.
To pass it, to get our
to pass the exams, right? Okay, so if the NCA adds 1 hour to your exam timing, does that mean you've passed?
No,
it doesn't. It's a procedural.
So, which means it's a procedural promise. But if the NCA says, well, because we are taking the exams online now, everybody that writes online has passed.
Oh, okay.
You really need to show up. Then that would be a substantive promise. And what does the syllabus says regarding procedural and substantive promise? The syllabus is saying that you cannot enforce it if it's substantive. I mean, if the decision maker gives you, stands by their promise, good. But if they don't, you cannot do anything about it. The only thing you can do is that it will lead to what? Enhanced procedural fairness obligation. Exactly what that means, we are going to consider it subsequently. I want to show you guys. Yeah, you can see the syllabus says for legitimate expectations, note the court's views on procedural versus substantive promises. For the night trigger, the reading talks about, this is not what I'm looking for. Yeah, this is it. The syllabus is saying with legitimate expectations, the content of the procedural obligation is generally what was promised in the procedural promise that gave rise to the legitimate expectation in the first place. If the promise was substantive, you will not be able to enforce it directly. But at the very least, it may lead to enhanced or more procedural fairness obligation. Now, moving on because of time, there's also the Canadian Charter of Rights and Freedoms, and the triggers are Section 7, life, liberty, and security. And just remember that the Charter of Rights, based on the authority of Iwin Toy versus Quebec, will not apply to non-individuals. Then the Bill of Rights, the triggers are Section 1A and Section 2E, and the Bill of Rights is only applicable to federal decision makers. That is, decision makers that were established by the Parliament. The ones established by the provincial legislatures, the Bill of Rights won't be applicable to them. And why is that? Does anyone know why that is? Anybody? Any educated guesses? It is because it's the federal legislation. The Bill of Rights was the predecessor legislation to the Charter of Rights, the first attempt before the Charter to codify human rights legislation in Canada. But the challenge with the Bill of Rights is it didn't really get the right kind of adoption they were hoping. And unfortunately, it's just a federal law. So provincial provinces are not really obligated to follow the Bill of Rights. They can, but they don't really have the obligation to. So which is why their decision makers too are not obligated to follow the Bill of Rights. However, the Charter of Rights and Freedom is different because it was attached to the 1982 Constitution. Because when they saw that this failed, then when they made this, they made sure to include it as part of the Constitution. And since the Constitution applies across Canada, it means the Charter is a constitutional document and it applies across Canada, which is why the Charter applies to every province and territory in Canada. But the Bill of Rights is only going to apply to federal decision makers. But the Charter of Rights applies only to individuals and not corporations, whereas the bill applies to both. Too much information? Are you good? Okay, just take it in. The whole idea behind this class is just to get you fired up to go and start your studies. I can't give you every info. In fact, there's some information that when I remember, I just decide not to talk about it because we will not get to the next topic, right? So you can't learn everything in this class. It's not possible. It's just to get you fired up. Now, Baker factors, you have to look at the Baker factors before you go into the content issues. And the Baker factors, there are 5 of them. We are going to look at whether we're going to consider the nature of the decision being made and the process followed, the nature of the statutory scheme and the terms of the statute pursuant to which the admin body operates, the importance of the decision to the individual, the legitimate expectation of the person challenging the decision, and the choice of procedure chosen by the admin body in question. So those are the 5 Baker factors. Now, there's a certain, there are different things we will need to consider under these 5 Baker factors. But then again, because of time, I'll probably just not want to go into detail and just move on to the next thing. Now, before we go, so now when you're done with your source, trigger, threshold analysis, when you want to go into the content factors, you look at the Baker versus Canada factors, which tells you a little bit about the the degree. Baker factors tells you about the content, about the degree. It helps you know whether the procedural fairness rights will be high or low. That is, the obligations is going to be high or low. Now, we can take a quick look at what the syllabus says about Baker. Okay, so can someone read these parts for us? Okay, we actually, we went through that already. Anyways, the Baker test suggests whether the content will be robust or not. That's what the syllabus tells us. How do you know whether it's robust? By going through the test, obviously. So when you go through the test, there are 5 of them. And when you go through the test, after you've considered your sources, when you go through the test, you see the nature of the decision and the process followed. And then the role of the decision maker within the statutory scheme, the importance of the decision to the affected individual, legitimate expectation of the person challenging the decision, and then the choices of procedures made by the agency itself. Now, for the Baker factors, you only need the majority. You don't need all of them to agree. You only need the majority of the factors to agree after you've done your review. For example, here, if it resembles a judicial process here, then it attracts more procedural fairness obligation. If it resembles a regulatory or legislative decision, it attracts lower level of procedural fairness protection. Now, the role of the decision maker within the statutory scheme, the courts are also trying to see whether the statute is more protective or more restrictive of the applicant. And things like whether there are appeal procedures, whether there are privative clauses. Privative clauses, by the way, means clauses that says you can't appeal a decision. So essentially what they just want to see is does the statute aim to protect the applicants, or does it aim to restrict their rights? If it is much more favorable to the applicants, then there's no need to expect more procedural fairness obligation. But if it is less favorable, then more procedural fairness protection will be expected. Now, importance of the decision to the affected individual. The more important it is, the more procedural fairness obligation that will be expected of the decision maker. The less important it is, the less that will be expected. If there's a legitimate expectation, involved, it also requires more procedural fairness protection. And here, what we are looking at here is the choice of procedure. We're looking at discretion. That is, does the decision maker have the choice to choose their procedures? If they do, and they chose a procedure that affects the rights, interests, and privileges of the applicants, then more procedural fairness obligation will be required from them. If they don't have the choice of procedure, that is, they are basically just following laid down laws by the lawmakers, then there's nothing they can do, and we can't expect more procedural fairness obligations from them. So when you are done with that, then you cannot go into your content analysis, discuss what notice is, discuss what discovery is, delay, oral hearing, open hearing, right to counsel, disclosure and official notice, cross-examination, reasons, bias, institutional bias, issues arising from institutional decision-making, agency lawyers, agency guidelines, and then when you're done, you conclude. And that's everything you need to know on procedural fairness obligations. And that's part A. But before we go to part B, which is the substantive aspect, there is something that I also want to quickly mention, just in case you choose not to join my class. I don't want to leave you high and dry. When it comes to Aboriginals, duty to consult for Indigenous people, the government, the NCA rather, they reviewed the syllabus, which means there's a bit of focus now on, duty to consult for and accommodate for Indigenous people. Let me see how exactly it is stated in the syllabus. Give me one sec. Yeah, constitutional duty to consult and accommodate Indigenous peoples. So this chapter was reviewed because I did a bit of review of the previous and new chapter, and they reviewed this chapter, which means they are thinking about it now. And ironically, they've never set any question on that chapter before, ever. At least since I started reviewing NCA exam questions. So maybe in the 1970s they did, I don't know. But I've never seen any question on it before, or I've never heard anyone say, I got this kind of question, or whatever. So it's possible maybe they have, and I just didn't hear about it, right? But the point is, if the NCA is focusing on it now, maybe they want to start, considering, setting questions on that, which is why I just want to quickly mention exactly what you are expected to do in the exams if you are faced with that, and if you end up not coming to my class where we will end up discussing it. Let me just quickly share something with you guys. I can't find the material anymore. Maybe we just keep it and move to the next thing. Where did I save this? Oh yeah, found it. Okay. All right, so when it comes to the duty to consult, of course, is there anyone here that has written Foundations of Canadian Law? Anybody? Anybody on the call? Oh, if there's no one, then I should probably do a bit of a background. We don't have time for this. So the Indigenous people were the ones on this land before the British came and the French. Based on the history, their origin was traced back to the Asians in a very thousands and thousands of years ago. They just came here, they settled here on, in the whole of North America generally, and they call it Turtle Island because they believe that the entire North America is on the back of a turtle. And their own idea, they are very connected to nature, which is why they also believe in living together on like reserves. Now, of course, the French came here, the British came here, the British fought the French and took over from the French. And when the British fought the French on the plains of Abraham in, what they called Quebec at that time. So after the war, they divided, Quebec into two, the Upper Canada and Lower Canada. Upper Canada was Ontario, Lower Canada was Quebec. Then subsequently, they created two additional provinces. I think it was Newfoundland and Nova Scotia, and then they created BC, and then they created Alberta, and they started creating more. I think Nunavut was the last territory that was created in 1999. Now, essentially what happened was when these guys when the British and the French came here, they saw that these Aboriginal indigenous people were living together in like small areas of land, and they had like vast areas of land that was uninhabited. So which is why it was easy for them to move in to the lands. But they never defeated the indigenous people. They didn't defeat them. They never lost to them. Obviously, they started coexisting, cohabiting. There's a whole lot that you're going to learn in between the lines when you do foundations of Canadian law. And issues started arising with regards to who owned the land. They started negotiating treaties and some land claim agreements, which are modern treaties. At a certain point, the government of Canada felt like, they were probably losing more to the indigenous people because they refused to leave their reserves, right? And because of that, the government of Canada introduced residential schools. The whole idea behind residential schools was to integrate them into the Canadian community. That is, they want them to go to Canadian schools, get married to Canadian, dilute their heritage, so that by the next 10, 50 years, there's really no indigenous population anymore. And the same thing is what is happening to immigrants. If you, as an immigrant, you come into this country, you are single, you get married to somebody else. If you are lucky, you probably find someone from your country. If you don't find someone from your country, you marry someone else, maybe marry someone from another race. Before you know it, you give birth to kids. Your kids are not going to say they're from your country. They'll say, I'm Canadian. And before you know it, that's it. You're gone. Even if you're married and before you moved here and you give birth to kids, again, your kids will not say they're from that country. They will say, we are Canadian. They'll marry their fellow Canadians, and before you know it, all gone. They probably won't speak the language anymore. Anyways, so the point was they were just trying to find a way to ensure that, there was a statement that they used then when the residential schools was being established. They said the goal is to kill the Indian in the child and kill the Indian in the child, because they felt like if they bring education to the reserves, they will only have what? Educated savages. But they don't, those are their words, not mine. But of course, it failed woefully. The residential school was a failure. There was a lot of rape activities going on. They were maltreating these indigenous kids. A lot of them died and were buried in mass graves. And you would have seen, the mass graves that was uncovered the other day in Saskatchewan, another one in Kamloops in BC, which is now, I even heard that a priest that raped an indigenous person almost 60 years ago was being tried recently. There's a lot of spotlight that is being shown on these areas these days. Now, there was an apology day when the then Prime Minister apologized to the entire indigenous, group, that they were sorry for what they were trying to do, because it really affected a lot of them, in the sense that after they went to those schools, most of them grew up in the schools. They were like boarding houses. When they go back to their reserves, they don't understand their language anymore. They can't eat their food. When they go back to the residential schools, they don't feel at home. So they are now in limbo. They can't go to school. They can't go back home, which is why most of them have that historic generational trauma. Because if somebody like that should not raise the kid will also get a bit of that. And that's why when you see them outside in the cities and you are like, oh, why are these guys looking like they're homeless people? It's not necessarily their fault. It's just basically the history of that generational trauma. Of course, There are some of them that are doing very well too. So it's not entirely like it's a bad, situation altogether. I've seen Indigenous lawyers, I've seen Indigenous doctors, I've worked with an Indigenous person that is a lawyer, very brilliant, and there are positive stories amongst them also. Now, the government, but in Section 35 of the Constitution in 1982, recognized these Indigenous rights. They recognize Indigenous Aboriginal rights, and they also recognize Aboriginal titles. Now, unfortunately, Section 35 only recognizes 3 types of Indigenous groups: the Métis people, the Inuit, and the First Nations. But there are several other Indigenous groups that may not be recognized in the Section 35 of the Constitution, but those ones are recognized in the Indian Act. Now, again, you will do more of these. This is more foundations of Canadian law. I'm just telling this story to kind of give you guys a background to why we're doing this. Now, in the process of exercising their rights, there will be times when the government will forget to consult them. So the duty to consult framework essentially began as an idea that if you want to do anything that will affect the right of Indigenous people, you have to talk to them first. But of course, the duty to consult framework is it's a farce, because they will tell you we have a duty to consult, but we don't have a duty to agree. That is, if we consult you and you don't agree with us and our plans as the government, we will still go ahead anyways. And there's an interesting article in Foundations of Canadian Law where the author says the author is a woman, and she likened this duty to consult to rape cases. Are you basically saying that a man can tell a woman, or a woman can tell a man, or any other gender can tell another gender that if I want to have sex with you, I have a duty to consult you, but if you don't agree, I don't have a duty to agree. I'll just go ahead and have sex with you. She was basically explaining that would not be allowed in any modern society. So if it's not allowed, then why is the government saying that we have a duty to consult the Indigenous people, but if they don't agree, we'll still go ahead and do what we want to do? Does that make sense? Anyways, it's a very interesting article. When you read Foundations of Canadian Law, you come across the article. I can't remember the title. And it really made me realize that the duty to consult framework itself is a trash framework. And she recommended a new framework called FPIC, Free, Prior, and Informed Consent. That you're not just consulting with us, you will ensure that you carry us along and we both agree to something before you go ahead. Not just like, oh, I have a duty to consult you, but I don't have a duty to agree. If you don't agree with me, I'm just going to go ahead anyways. Again, I understand the perspective of the government, because a government has to be able to carry out its activities, because if a group says you can't do it and they can't do it and they lose money. For example, something recently happened in our brother. They were trying to construct a pipeline that's going to bring millions, maybe billions to the province. An Indigenous group they said, you cannot construct a pipeline on our land. You will affect our connection to nature if you do that. Of course, the government will only be seeing the billions and the thousands of jobs that's going to create. But Indigenous groups are saying, well, we have a connection to nature. If that pipeline runs on that land, it affects our connection to that, on that ground, and all that. Anyways, so now when it comes to admin law, there are times when these consultation processes has to happen through administrative agencies. Now, these admin agencies are still technically, remember, admin agencies were created by law, but they are what? They are functioning within arm's length of the executive. So which means they are still technically representing the executive arm of government that ought to do the consultation, which is why you see all this blob as to where it has been recognized. So Sina talks about this, Make It Silk Crew talks about that. Now, when it comes to the source for Indigenous group, the number one source is the Section 35 of the Constitution Act of 1982. And when you want to look at the trigger and threshold analysis, what you want to consider, the duty is triggered, number one, when the Crown has actual or constructive knowledge of a potential Aboriginal claim or title. Now, this may not make sense to you until you study, so don't bother, okay? When there is a contemplated Crown conduct or pending Crown decision, and finally, when there is a potential adverse impact of the Crown conduct or action on the claimed Aboriginal rights, then we can say the duty to consult has been triggered. Now, when it comes to the content, what is the contents of this duty? Remember, that duty to consult is the procedural fairness obligation for these Indigenous groups. which is different from the other procedural fairness obligation that we discussed. Their own is subsumed in that duty to consult. So what is the content? So now, what the court is telling us based on prior jurisprudence is that these contents will be dependent on the strength of the claim. The content should begin with an evaluation of the strength of the claim. Weaker claims and lower levels of impact will result in procedural obligations at the lower end of the spectrum, while a stronger claim will attract a deep and meaningful consultation process. And as you can see, these are the procedural rights when it is a weak claim. These are the procedural rights when it is a strong claim. And it's almost a bit similar to what we talked about. You can see notice, you can see time to prepare a response, you can see right to hearing, you can see full and fair consideration, formal participation in the decision-making process, you can see provision of reasons, almost very similar. So I just thought I'd quickly mention that briefly, before we move on to, what's it called? Before we move on to, actually, it should be in the framework. I think the duty to consult should also be in the framework. And by the way, in case I haven't mentioned this, so this framework that you guys have on your screen right now, it's not a notes. It's not a notes. It's an exam companion. It's available on the website if anyone wants to get it. But I recommend that you don't get it now because you probably won't understand what it's saying. It makes a lot of sense to get it after you have studied, you know exactly what the course is talking about, because this is not a note. It's more like something you need to have by your side in the exams. It makes it easier, and you understand when you study and when you get it, you understand it to make more sense. Any questions? Any questions before we go to the substantive review?
No.
Okay, so for the substantive aspect of our discussion, we essentially want to ask ourselves, remember, we have been discussing the procedures. That is, when a decision maker is faced with a decision or has made the decision and we want to review that decision, we initially have to consider the process that they followed, right? Now, we are no longer interested in the process anymore to know whether it is fair or not fair. Now, we're interested in knowing whether the outcome of the decision itself makes sense. Now, in identifying whether the outcome of a decision makes sense or not, we need a standard to review that decision to know whether it makes sense. Because we can't just say, hey, the decision for you not to turn on your video, because I see a lot of people not turning on their video right now, and we now say, oh, the decision not to turn on your video is a wrong decision. We can't just say that. We need a standard, like a marking scheme, to evaluate that decision to now come to the conclusion that it is not the right decision. And that standard, or those standards, are what we refer to as the standard of review. Shinal, you have a question?
Yes, yeah, because when you asked earlier the question, if you have a question, I said, no, that was, I just remember. So when you mentioned earlier about the Baker test, right? And there are five factors. So in order for you to like get whether or not, you to apply it, whether it's a higher degree or a lower degree, do you need all five of the tests to be satisfied, or one?
No,
two,
I mentioned it when I was talking about it. I said you don't need all five, that you only need majority of the five, which is 3.
Okay, so one or two won't suffice. You need 3 or more.
Yeah, 3.
Okay, thanks.
All right, so as I was saying, for the substantive review aspect, you need the standard to review the decision by to know whether it's a good decision or bad decision. And these standards are what we refer to as the standard of review. Now, the standard was initially set in the case of, we initially had 3 standards of review. We had reasonableness, simplicity, patent on reasonableness and correctness. And then in Dosmere in 2011, I think 2011 or 2010, Dosmere fused the 2 reasonableness standards into one. And then we had reasonableness and then we had correctness. Then in December 19, 2019, Vavilov also reviewed the existing standard of review. The case of Vavilov now introduced reasonableness, correctness, and palpable and overriding error. So those 3 standards are the standards that we have till date that you were expected to, use in your exams. Now, those are the 3 standards of review. But how do you identify what standard to use? Because we have 3 standards of review now, right? Reasonableness, correctness, palpable and overriding error. So how do you know which one to choose? Vavilov now presents to us a selection process to identify a standard. And that process, Vavilov is saying, you must always start with a presumption that reasonableness is, first of all, your standard. Start with that presumption that, okay, as I'm about to review this decision, reasonableness is my standard. Now, let me try and rebut that presumption. So now there are 2 major ways you can rebut the presumption. The first major way is the legislative intent category. And the second one is what? The rule of law category. Now for the legislative intent, the court is saying, ask yourself whether the enabling statute, remember we talked about the enabling statute of the decision maker that established the decision maker because they weren't wished into existence, right? That enabling statute, ask yourself, does that enabling statute provide for a standard? Remember, this is the legislative intent category. It means that the court will follow whatever the intention of the lawmakers are. So if the lawmakers had any intention of a standard that they want or they wanted, they will include it in the enabling statute and say, if there's any dispute or any issues, apply this standard. And the court is saying, we don't care. Whatever it is, we apply that standard. More often than not, you probably won't see this because, again, Vavilov is a 2019/2020 decision. Not many decision makers have been established between that time and now. And I don't think they've really reviewed their laws. Maybe the new decision makers, they will start including them from the next 1, 2, 3, 4, 5 years from now. Then the next one is ask yourself if there's a statutory appeal mechanism. That is, does the enabling law, which was prepared by the lawmakers, did they provide that there should be a statutory right of appeal? When there's a statutory right of appeal, it means statutory right of appeal basically means the right of appeal in the statutes. And there's a difference between statutory right of appeal and judicial review. Statutory right of appeal is the right to appeal a decision because the statute says you can. Judicial review is the right to appeal a decision on the authority of the rule of law, right? And if there is a statutory right of appeal, you now need to ask yourself a couple of questions. Is the nature of the issue under determination a question of law, or is it a question of fact or mixed fact and law? Because if it's a question of law, your standard is the correctness standard. And if it is a question of fact or mixed fact and law, your standard is the standard of palpable and overriding error. Now, the rule of law category talks about constitutional questions, questions of jurisdiction between 2 or more administrative decision-making bodies, and matters of central importance to the legal system. If your issue falls under any one of the 3, then the rule of law applies, then the standard of correctness applies. However, if you're unable to rebut the presumption of reasonableness, then you go back to the standard. And this is exactly what it looks like when you are going through the selection standard. This is what it looks like. First, identify the standard of review. And to do that, start with the presumption of reasonableness according to Vavilov. And the next step is to try and rebut that presumption. Ask yourself if the statute provides for a standard. If the statute provides for a standard, apply that standard. If the statute doesn't provide for a standard, ask yourself if the statute provides for a right of appeal. If it does, you need to ask yourself a couple of questions. Is the nature of the issue in question that of law, or is it that of fact or mixed fact and law? If it's a question of law, correctness is your standard. If it's a question of fact or mixed fact and law, palpable and overriding error is your standard. If it doesn't provide for a right of appeal, then you need to ask yourself if it is a matter of a jurisdictional question between two or more administrative decision makers. If it is, correctness is your standard. You can also ask yourself if it is a question of central importance to the legal system. If it is, correctness is your standard. Ask yourself if it is a constitutional question. If it is, correctness is also your standard. If you're unable to rebut the presumption, then standard of reasonableness applies nonetheless. Now, when it comes to the constitutional questions, there's a bit of a challenge in the sense that you still need to also ask yourself if Dory should apply. So the case of Dory was decided before Vavilov, and Dory, exactly just provides for what should happen where you are considering charter-related issues. And in Vavilov, the majority were silent. Now let's see what the syllabus says about Dory before I give a bit more of a detailed explanation on that.
More importantly, understand Vavilov's elaboration of how to conduct reasonableness review, the now prominent standard on applications for judicial review, although not statutory appeals. As part of comprehending the changes and elaborations contained in Vavilov, pay attention to the exceptional circumstances when correctness, not reasonableness, is the standard on applications for judicial review. Make sure you can identify the characteristics of those exceptions. Also appreciate the reasons why the court rejected previous case law, which accepted that reasonableness was the presumptive standard of review, even for matters on which the legislature had provided for appeal rights. I should continue?
Yes, please, yes.
Okay. Also pay attention to the 2012 wrinkle introduced by the SCC in Dory, a wrinkle to which the majority paid little attention in Vavilov, see paragraph 57. Dory looks at what standard of review is applied to an exercise of discretion by an administrative decision maker who is considering a charter right in making their discretionary decision. Short answer, reasonableness. Longer answer, but it may be a different kind of reasonableness review. Reflect on how, if at all, the Dory approach has been interpreted and or modified by subsequent case law, such as Trinity Western University, and implicitly, if at all, by Vavilov. Okay, once you have determined the appropriate standard of review, correctness or unreasonableness, you may also be required to apply that standard to a substantive ruling or decision. For this, you should be familiar with the standards and tests that the SCC has identified for conducting this exercise and be able to use them appropriately. In particular, continue to reflect on the SCC's elaboration in Vavilov of the context-sensitive nature of reasonableness scrutiny, and how the court went on to determine that the decision under review was unreasonable. What role does the obligation to give reasons for a decision and any reasons that are given play in the determination of whether a decision is unreasonable? Consider also the companion judgment in Bell, Canada, where the SCC applying Vavilov deploys the standard of correctness in a case which commenced by way of a statutory appeal from a tribunal's determinations of questions of law involving statutory interpretation. Appreciate what correctness review involves in both this setting and also those now infrequent situations where correctness will be the standard of review on applications for judicial review. A word of warning: when it comes to an examination, if selecting the standard of review arises on the facts, you do need to consider the applicable approach as formulated in Vavilov and Bell Canada. The contextual four-factor standard of review analysis, as refined in Dosmere and its progeny, is no longer good law and will not serve as the basis of an acceptable response. On the exam, no marks will be awarded for any answer relying on this non-superseded case law.
Yeah, thanks. Thanks, Chinyere. So that's I hope everyone paid attention to what she was reading and you were just not zoned out, especially this part. The syllabus says, pay attention to the 2012 wrinkle introduced by the Supreme Court in Dory, a wrinkle to which majority paid attention to in Vavilov in paragraph 57. Now, we don't have time to go through Vavilov today. Dory looks at what standard of review is applied to an exercise of discretion by an admin decision maker who is considering a charter right in making their discretionary decision. Short answer, reasonableness. Long answer, a different kind of reasonableness. What does that mean? Basically, what they're saying is that when charter is involved, remember when we talked about your sources of procedural fairness in the first part, once you can say the charter has been triggered here, it means charter issues are involved. And when you get to the substantive review aspect where charter issues are involved, you don't, you state this selection standard, but you can't stop there. You need to come and consider the Dory wrinkle. And why do we call it a wrinkle? It was decided before Vavilov, but in Vavilov, the majority somehow carved out a part of Dory and decided that that part would be decided by Vavilov, and they were silent about the other part of Dory, which means the other part continues to operate, notwithstanding that Vavilov came 7 or 8 years after Dory was decided. So what part did the majority carve out? They carved out this part saying when a charter issue is involved, there are two questions you should ask yourself. The very first question is, was it the decision of the decision maker that affected the charter rights? And the second question is, was it the interpretation of the enabling statutes? You know what? Let's take a look at Vavilov right now. I have a feeling that we should take a look at it. Like I said, you guys have access to LexisNexis based on your NCA exam registration, so don't hesitate to always look up cases when you are confused, especially if you are not in a discussion with anybody else and you're just studying all by yourself. So let's go to paragraph 57. So paragraph 57 here says, it is important to draw a distinction between cases in which it is alleged that the effect of the admin decision being reviewed is to unjustifiably limit the rights under the Canadian Charter of Rights and Freedom, as was the case in Dory. So this is the first part now. That is, it is the decision. So there are two things that affect charter rights, according to Vavilov now. The decision, then the enabling law. So this part, they are saying, if the decision based on Dory affects it, that's one. And the second one, they are talking about those in which the issue on review is whether a provision of the decision maker's enabling statutes violates the charter. That's the second part, the enabling statutes. So the court divided charter-related issues under substantive review analysis into two: enabling law, discretionary decision. And the court is saying, our jurisprudence holds that an admin decision maker's interpretation of the latter. When we say latter, what do we mean? The last one, right? Not the former. And the latter is this one in lemon right here. That is the enabling statute. And the court is saying our jurisprudence holds that the admin decision maker's interpretation of the latter should be reviewed for correctness, which means whenever you are reviewing a decision that has triggered a charter right, you have to ask yourself, is it the decision itself that triggered that charter right, or the enabling law of the decision maker. Because once it is enabling law, it should be correctness. But because the court was silent on what happens to the former, most jurists and admin law experts have continued to maintain that Dory continues to apply where it is the decision. That is, it's going to be a reasonableness analysis according to Dory. Now, remember we said there are 3 standards of review based on Vavilov. That there's a reasonableness standard, there's the correctness standard, and then there's a palpable and overriding error standard. Now, I dare to say there's an additional standard. Now, people don't like to say it's an additional standard, but it is an additional standard because this reasonableness standard, according to Dory, the analysis is not the same as the regular reasonableness analysis according to Vavilov. And I didn't make that up. It's in the syllabus too. The syllabus also mentions, the syllabus says, short answer, what is the standard? Reasonableness. Long answer, but it may be a different kind of reasonableness review because the Dory reasonableness is not considering the intelligibility in the decision-making process and whether it falls within the range of acceptable outcomes. No, the Dory reasonableness is considering whether you can balance the charter rights with the objective. And you will see things like, I know I have some information on that, how to conduct a reasonableness review when you're considering charter rights. This is the regular reasonableness standard, and this is the regular correctness standard, palpable and overriding error standard. And now, when there's a charter right triggered, it's a different thing. So in Dory and Loyola, the courts held that where an admin decision engages a charter protection, the reviewing court should apply what we refer to as a robust proportionality analysis consistent with admin law principles. Now, this proportionality analysis is very similar to what we call the Oakes test in constitutional law, because in constitutional law, once the charter right has been infringed, the next thing is you go to section 1 of the charter, which talks about limiting charter values in a reasonable and demonstrable democratic society, blah, blah, blah. And then you consider the Oakes test to see whether it's proportionate, whether there's a substantial objective, whether there is a minimal impairment, and I can't remember the 4th one. But in admin law, it's different. It's the same thing, but it's different. And the court basically says, you should use the proportionality analysis consistent with admin law principles instead of a literal section 1 approach. And the same thing was also held in ETL meeting. And they are saying that for it to have been triggered, for it to be considered, the charter right must have been triggered. In Law Society of BC versus Trinity Western, the court also said it's not enough for it to be proportionate, and it's not enough to simply balance the statutory objectives, that the reviewing court must be satisfied that the decision gives effect as fully as possible to the charter protections at stake, given the particular statutory mandates. Again, objective of the decision maker, what they were trying to do that made them breach or infringe on the charter rights. And again, what is the charter right? Is it affecting it more than it's necessary or more than it needs to? So that is the approach in this second type of reasonableness. So it is very safe to say we have the regular reasonableness, according to Vavilov, correctness, palpable and overriding error, and then we have the Dory reasonableness analysis. So it's safe to say we have 4 standards, but then again, technically we have 3 standards. I hope what I'm saying makes sense and I'm not confusing you guys. And when you're done with that analysis, of course, in the standard of review, the first thing is you want to identify your standard. So you go through the selection process. Now, when you have identified your standard, the next thing is to apply the standard. If you identify the standard of reasonableness, the next question you ask yourself is, so was the decision reasonable? If you identify the standard of correctness, the next question is, was the decision correct? If you identify the standard of palpable and overriding error, then you want to know whether there is an error that is palpable and overriding that will require the court to what? Interfere with the decision. So when we're looking at reasonableness review, how do you conduct a reasonableness review? Of course, you have to start with the reasons. That's why we call it reasonableness. You are trying to see whether there is a reason that makes sense. for them to have arrived at that decision. It will require you to sort of step into the shoes of the decision maker. It requires a bit of dancing around, which is why you see that they say a reasonable decision must be internally coherent. It must present a rational chain of analysis. It has to be justified in relation to the facts. It must be justified in relation to the relevant law. And of course, the court told us what to do in Vavilov, where no reasons are provided, because reasonableness decision must start with the reasons. So what happens if reasons are not provided? The court mentioned that there are 3 situations, that in situation 1, where reasons are required but are not provided, the matter is generally going to fail. But where reasons are not required and not provided, then you must look to the record as a whole to determine what the reasons are. And in situation 3, if the reasons are not required, they're not provided, you've looked at the record as a whole, you still don't get exactly what the reason for the decision is, then the court is saying you should still examine the decision in light of the relevant legal and factual constraints that must have affected the decision maker. And that will help you know whether that decision is a reasonable decision or not. Now, when it comes to the correctness is not a differential standard. When we say deference, what do we mean? Deference is just basically believing that the decision maker knows more or knows enough for you to respect their decision and not just interfere with it unnecessarily. Which is why when we say reasonableness is differential, when the court even finds that the decision is unreasonable, usually the practice is to return it back to the decision maker to re-hear the matter, because they believe they are the experts. For example, Investment Industry Regulatory Organization of Canada, it's a securities administrative decision maker. I don't expect a judge of a court to know more than them on securities law. It doesn't mean it's not possible that there will be a judge of a court that knows more than them on securities law, right? But I would expect that they are experts and they should know more than a regular court judge. Now, they are most likely going to apply a differential standard like reasonableness to their decision. But correctness is not a differential standard. And correctness doesn't require the court to look at the reasons. They don't need to do any dancing around or try to step into their shoes. Correctness requires that there is one answer. And the court will formulate its own opinion as to what the right answer is. And if the decision of the decision maker doesn't match that right answer, then that decision is always going to be incorrect. And you will see when we did the analysis, if you remember our analysis, you will see that the kind of decisions that attract correctness standard are usually matters that involve the law. Look at it. Does the statute provide for a right of appeal when it's a question of law? Correctness. Is it a matter of jurisdiction? Correctness. Between 2 ADMs? Correctness. 2 or more ADMs rather. Correctness. Is it a matter of central importance to the legal system? Correctness. Is it a constitutional question? Again, law. Correctness. Even when we get to the Dory Wrinkle, when it was a discretionary decision, it's not correctness. But when it comes to the enabling statutes interpretation, again, matter of law, correctness. So you will see that the nature of the issues that require correctness, legal issues. And when it comes to interpretation of the law, the court will always prefer that there is one answer. And if the answer of the decision maker doesn't match that of the court, it will always be held to be an incorrect decision. Now, when it comes to the last standard, which is the standard of palpable and overriding error, this is also a differential standard. But this is a big difference in the sense that the court is just saying that we will not even interfere with the decision at all. If you come to us to say you want us to review this decision, we will not, except you can tell us that the decision is palpable and there's a palpable and overriding error with the decision. So what do you mean by palpable? Palpable means plain to see. The same way I can see that you guys have refused to turn on your videos. So it's easy to see that. I don't need any special lenses to identify that. Overriding error means an error that goes to the roots of the decision. So except that error is plain to see and it's overriding, which means it's not just, the error should not just be plain to see. It must also be overriding. So because if the error is not even plain to see, they won't interfere. If the error is now plain to see but not overriding, they still won't interfere. So it has to be both plain to see and overriding. And if it is both, then they will now interfere with the decision and say, okay, we need to now review this decision because there's obviously a palpable error that also goes to the root of the decision. And what are examples of palpable error? Palpable errors include things like findings made in the complete absence of evidence, findings made in conflict conflict with accepted evidence, findings based on misapprehension of evidence, and findings of fact drawn from primary fact that are the result of speculation rather than inference. Now, an overriding error, is an error that's sufficiently significant to vitiate the challenged finding of fact. That is, it goes to the root of the challenged finding of fact such that the fact cannot safely stand in the face of that error. Again, if you haven't studied before, this probably wouldn't make sense to you. And the purpose of this class isn't to make you feel bad that you don't know this. It is to make you feel good to start studying towards understanding this. So you should not be worried that, oh my God, I have a lot to study. You should be, fired up and be excited that, yes, I'm going to start my studies immediately. And of course, when you're done with your substantive review analysis, you have to consider the remedies applicable to the applicants. We have some remedies like prerogative writ like the certiorari, prohibition, mandamus, declaration, habeas corpus, quo warranto, and private law remedies like money and damages, monetary damages for charter breaches, special tort of misfeasance, malfeasance in public office, and all that. And that's everything you need to know from the big picture perspective when it comes to Canadian administrative law. Remember, broadly divided into procedural fairness and substantive review. And of course, you'll have to discuss the remedial nature of the application itself when you are done. Any questions?
Okay, a definite answer. Okay. So far, so good.
All right, sounds good. If anyone is interested in registering for the general classes, you can send me an email at kenny@ncaguides.com, or you can just go to our website and register online. And if in the alternative, you are not interested in having general classes, you want to have private classes, like one-on-one sessions with just you alone, please feel free to also reach out to me, kenny@ncaguides.com. So this is spelling of Kenny, then at ncaguides.com. And for the people that will be joining me in 2 weeks, I look forward to seeing you, and hopefully we can have a productive time together. In the absence of any further questions, I wish you guys a wonderful weekend.
You too. Thank you so much.